And to know, may we know, Mr. President, if the defense has already complied as of today? Because they have not yet complied as of the 27th and yesterday.
Yeah, but the way we understood, if Your Honor, please, the way we understood it, we have the whole day today. We are filing it today.
Are you ready to present a list of your witnesses?
Yes, Your Honor, it's being finalized on.
So,
Okay, we hope we get it today, Mr. President, because
Why
we
will that-
complied with respect to the prosecution, we complied on the 27th.
Yeah,
But anyway, we can proceed now. We are ready to proceed.
All the while, I have the impression that you utilize it as your evidence. That's why you're asking.
We just want to know. We just want to know because we have 100 witnesses and we complied with it and all the documents.
Yeah,
but anyway, we can call now our first witness, Mr. President. This is our first witness for the day and the 10th.
so that we can minimize this exchange of words, I would suggest that henceforth the parties would supply the other party of any pleading that or any document that you will submit to this court. If that is agreeable to both the panels.
Yes, Your Honor, Mr. President, we're doing that.
For the defense, we submit to the discretion of the court, Your Honor.
Thank you. So proceed. Call your first witness.
We're now ready to call our first witness for the day and the 10th since the beginning of the trial.
Yesterday, Your Honor. I'm sorry. Sige, go ahead.
Can I? Thank you. This is Mr. Director. The name is Director Benito Cataran, the Director of the Corporation Registration and Monitoring Department of the Securities and Exchange Commission, or SEC. May we call now Director Benito Cataran? Mr. Cataran?
Mr. Chairman, Mr. President,
The defense counsel.
yesterday, Your Honor, we were made to believe that their next witness today will be the lady referred to by Mr. Nang? Mr. Nang, Your Honor, the marketing director of Mega World, Your Honor, because we did not continue further with our cross-examination in the hope and in the belief that that witness will be offered today. May we be informed?
For the information of the impeachment tribunal and the defense, we requested for a subpoena yesterday, and it was issued. And I think we were informed, Mr. President, that the marketing director of Mega World is directed to appear tomorrow by virtue of the subpoena issued by this impeachment tribunal. So we may present the marketing director tomorrow.
Anyway, are we still on Article 2?
That's correct. Still Article 2.
This witness is presented under Article 2. The gentlewoman from Taguig.
Mr. President, just a clarificatory question on the witness from Mega World yesterday. I'd like to know how we should treat his testimony in the light of the fact that it was established, I believe, through, I think, questions of some senator judges, that it was hearsay because he himself admitted that he is not familiar with certain information he testified to. So do we treat that as hearsay? Do we consider that stricken off the record? I'd like to know because it was a very lengthy testimony.
That was objected to by the defense. And then I asked a clarificatory question, and indeed he said that he was told. So I ordered that it was subject to the hearsay rule, meaning that it was not disallowed to enter the record. And so I asked the prosecution to the presenting counsel of the prosecution to reform his question, and so the record will bear out the result.
Okay, so perhaps I will just reserve my right later, and I'll just go over the record and see what is there. Because I do recall that it wasn't just one or two statements. It was quite a lengthy statement, and in fact, it was a continuing response to a number of questions. I will just look at the records and then make my further comments then. Thank you.
At any rate, in the appreciation of the evidence, the court can segregate the hearsay testimonies from the factual. So I think we can dispose of that at a later date. This is an SEC, Securities and Exchange Commission officer, now being presented as a witness under Article 2. What is the relevance of this witness to Article 2?
I'll just give the floor to Congressman Ray O'Malley, who will conduct the direct examination. Congressman O'Malley, Mr.
Yes,
President.
but I would like, the chair would like to know the relevance of the SEC in this proceeding. Will counsel please explain?
Thank you, Mr. Senate President, Your Honors. Let me just explain, Your Honor, that the relevance of presenting this SEC official is to amplify on points pertaining to the Basa Guidote Enterprise Inc., which appeared in the SAL-ENS, or Statement of Assets, Liabilities, and Net Worth, which was hesitantly presented by the Clerk of Court of the Supreme Court. And in this particular SAL-ENS, particularly Exhibit C, D, E, F, G, H, I, J, K, and L, which were also adopted as common exhibits by the defense, the name of Basa Guidote Enterprise Inc., where it showed that there was a cash advance of 11 million was reflected in the liabilities column of the SAL-ENS, Your Honor.
Cash advance of the corporation to whom?
Allegedly to Renato Corona, the respondent in this case.
How would the SEC know about the details of a cash advance by corporation to someone?
Yes, Your Honor.
Their duty is only to record the records of a corporation.
Yes, Your Honor. That's why in this particular instance, the prosecution will prove that as of 2003, calendar and fiscal year 2003, this Basa Guidote Enterprises Inc., Your Honors, had been revoked, and therefore its corporate existence. Revoked, yes, Your Honor. The corporate franchise.
The license has been revoked.
Yes, Your Honor.
Revoked.
Yes, Your Honor.
To operate as a corporation, but it was not dissolved as an artificial person. Was it dissolved as an artificial person by the revocation?
As a juridical person, Your Honor.
That's right. Was it revoked?
Yes, Your Honor.
As a juridical person, I doubt it.
Yes, Your Honor.
The only one that can dissolve it are the stockholders.
No, Your Honor. What happened here was for failure to comply with the reportorial requirements as required under the Corporation Code, and this happened from 1990 to date, Your Honor.
This is a legal question, whether the order of the SEC to prevent the corporation to transact any business because of certain non-fulfillment of regulation would mean a disillusion of a corporation. Although this is a legal question, let's hear the witness. Okay, you proceed.
Yes, Your Honor. Thank you, Your Honor.
It's up to the defense counsel to protect the interest of his client.
If Your Honor, please, may I be allowed to say a couple of words?
Please, go ahead.
If the witness on the stand, Your Honor, will be testifying on legal matters, I do not think that could be the subject of his testimony, because as a witness, what can be covered by the testimony of a witness are only factual matters, never legal matters, Your Honor. Because that should be addressed. I'm sorry, Your Honor.
Precisely that the chair asked whether he was, what is his relevance. And now it turns out that he's going to discuss a theory that has not been established by, I don't know of any jurisprudence that can be cited about this, but I would like to give them all the opportunities to prove the case, and let us hear the testimony.
We'll just make up. May I be allowed?
Yes,
Your Honor?
please.
We will just make up record, Your Honor, our objection to this kind of testimony, Your Honor, because if it deals with legal matters, then the witness will be entirely incompetent, irrelevant, and immaterial.
You can register your objection.
Thank you, Your Honor.
Yeah,
We
proceed.
did.
Mr. President,
The Majority Floor Leader.
Mr. President, before the clerk of court swears in the witness, the clerk of court also of the impeachment court would like to inform the body that they have served the subpoena to the senior vice president of Mega World 9 a.m. this morning, received 9 a.m. this morning, but was asked to appear at 2 o'clock this afternoon, today, not tomorrow. 2 o'clock in the afternoon at the 31st day of January, just for the record.
Was there any return showing that he received the service?
Nandiyan ba?
Yes, at 9 a.m. This morning, Mr. President.
Well, we will cite him for contempt.
May we know if she is around, Your Honor?
We will cite him for contempt for not complying with the order of this court.
Mr. President, we've been informed that he's here just now.
Ayun pala naman.
He is here.
Yes.
Sir,
Would you be informed?
Then put him in the witness stand first.
He just arrived now. We were informed, Mr. President, that he just arrived now, so he's here.
So what is the pleasure of the prosecution now?
We just present first. If we may just present first the SEC.
Why don't you, for the orderly proceeding in this case, why don't you finish with the Article 2 in relation to the testimony of the previous witness? Because the testimony of this summoned witness is connected with that, so that we can finish instead of jumbling the records. Is he here?
He's here,
Swear
Mr.
the
President.
witness and
Please
before
raise
this,
your right
question.
hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this, before this court?
Yes, Your Honor.
So help you God.
So help me God.
Proceed.
May we request that Attorney Joseph Jomer Perez be recognized to conduct direct examination, Mr. President.
Attorney
Joseph Jomer Perez.
Attorney Perez may proceed with the examination.
Thank you, Your Honor. Your Honor, the testimony of this witness is being offered to prove that the spouses Renato and Cristina Corona bought and acquired a penthouse unit with 3 parking slots in the Bellagio 1 condominium in 2009 for the purchase price of 14.5 million pesos after receiving